Hello all, welcome to this YouTube channel which updates you about ESIC. I'm Jitendra. Today's video is about type of notices from ESIC Part II. And first part we had seen what is C18 ad hoc, what is C18 actual. In this part we will see what is C19 orders under section 45A, orders under section 45AA and the other things related to them. Important information for all of you. Today onwards all of my videos will be in Hindi as well as in English. The videos which are posted with prefix H will be in Hindi and the videos which are posted with prefix E will be in English language. This is according to the request received from some of the viewers that they are not able to understand Hindi properly. The slides or presentations on the screens will be bilingual as usual, but the information will be either in Hindi or in English. I hope it will reach out to maximum people and it will help others also. So we'll start with today's video where we will see C19 notice, 45A orders, appeals against 45A orders and orders under section 45AA, appeal against that. Please subscribe to this YouTube channel and my Telegram channel so that you can get direct link on your mobiles about the videos that I post. If you have any feedback or you want to have some doubts cleared, you can contact on my contact details shown on the screen. Thank you so much. So we'll start today's video. You can see on the screen how the notices in ESIC work step by step. They go as shown in the diagram. You can see default happens, then the D1, D2, D3 notices may be issued. If there is no compliance by the employer on the D1, D2 notices, then C18 actual or C18 ad hoc notices are issued. C19 actual, if complied, then notice is closed. If not complied, then it goes to C19. C19 is recovery procedure. The recovery officer recovers those dues, and then once the dues are received, interest and damages are claimed for the delay in making the payment. In the same way, C18 ad hoc, once it is issued, personal hearing is given to the employer. Based on the personal hearing and the record produced, 45A order is passed. If it is complied, then no action till the date of payment, interest and damages are recovered. If it is not complied, C19 notice is issued. C19 notice takes care of recovery procedures, and once the principal is received, interest and damages are recovered. If you appeal 45A order after the hearing, order under section 45AA is issued. If it is complied, no action, only interest damages are recovered. If it is not complied, it goes to C19. C19 is once issued, recovery is made, and then interest and damages are recovered till the date payment is received. If 45AA order is not complied, then C19 is issued. Once the C19 is issued, recovery procedure is done. Once the recovery is made, again the matter goes for interest and damages. And if 45AA order is to be disputed, then you have to go to the court. There also, once the principal amount is recovered, interest and damages are also recovered. This way it works. It is a brief diagram. Once you go through the video, you will be able to understand it better. You see this diagram once again after the video. So what is C19 notice? C19 notice is a letter written by the authorized officer of ESIC. It is a letter written by authorized officer of ESIC to the recovery officer of ESIC. Copy of it is sent to the employers. It says that authorized officer has assessed so much of amount of contribution payable from the employer, and that has to be recovered. After C18 actual, C19 immediately follows. In C19 it is clearly mentioned that till the date of payment, interest will be payable. So simple meaning is that till you pay the amount, interest calculation will go on. The more you delay the payment, the more will be interest amount you pay to ESIC. It is clearly mentioned in the notice. So it is always better either to approach court in case you dispute or to pay the amount in case you agree, but do not delay action on C19. C19 notice is also issued when the orders under section 45A and under section 45AA are not complied by the employer, neither they are disputed by the employer. So if you have received orders under section 45A and orders under section 45AA and you have not complied on those orders, then also C19 will be issued. So simple thing to understand: if you dispute, then challenge. If you don't dispute, then pay immediately. So what is order under section 45A? C18 ad hoc gives you opportunity for personal hearing. As you have seen in the previous video, that personal hearing is for producing records and supporting documents for the determination of contribution payable from the employer. Ad hoc is issued on the basis of presumption or on the basis of old records available with ESIC. The situation may be different for the period under consideration, and records for the concerned period are to be produced before the authorized officer of ESIC. On the basis of records produced before the authority is competent to determine contribution payable by the employer. Three things can happen. Employer may remain totally absent and may not attend personal hearing at all, so the amount determined through C18 ad hoc will be final contribution payable by the employer because the claim has not been disputed by the employer. Second option, you may appear for personal hearing and produce supporting documents completely. On the basis of records, the authorized officer will verify the records and determine contribution based on the records produced before him, and he will order the employer to pay the amount so determined through order under section 45A. So order issued under section 45A is speaking order, and it clearly quotes grounds on the basis of which the authorized officer has reached the conclusion. Third option is that you have produced some records and some of the records you don't have. So partial records you have produced. Authorized officer will also issue 45A order, speaking order, on the basis of available records and those which are lacking. So he has discretionary power, and on the basis of that also he will claim certain amount. Just for example, suppose you cannot produce records supporting separation of wages and material component in particular work. So in that case, authorized officer is competent and has discretionary power to determine contribution in such cases. Order under section 45A is issued on the basis of records produced or record not produced based on the outcome of the personal hearing. The amount so determined under section 45A has to be paid, and if you do not agree with the assessment of the assessing authority and 45A order and contribution determined as per 45A order, then you can appeal against the order within 60 days of receipt of order under section 45A. There are 2-3 conditions which are important to appeal against the speaking order under section 45A. First important condition, appeal has to be filed within 60 days of receipt of 45A order. Second condition, you have to deposit 25% of the amount determined in 45A or the contribution payable according to you, whichever is higher, to the ESIC in ESIC fund account number 1. And third important thing, you have to give all the supporting documents on the basis of which you are disputing 45A order or you are challenging 45A order. The grounds for challenging 45A orders concerned records are to be enclosed with the appeal. The appeal can be filed in the same SRO or regional office from where you have received speaking order. The authority to accept appeal against 45A is last authority in ESIC to hear any dispute regarding 45A order. They are senior officers of the rank of joint director or regional director, and once order is passed by them, there is no other solution but either to pay the amount or go to the court. So the 45A order has to be disputed only if reasonable grounds, strong supporting documents are available, or there is a significant question of law. Then only employer may dispute order under section 45A. Here also, when employer appeal against 45A order and produces concerned record, the appellate authority passes an order under section 45AA. So appellate authority under section 45AA issues another order, and that order is binding. If employer wants to dispute that order also, he can go to court or comply with the amount determined in speaking order issued under section 45AA. So this is how the determination of contribution part, which starts from issue of C18 ad hoc, ends at the most at the level of 45AA. After 45A or 45AA, if employer does not appeal, then he has to comply with the order and pay the contribution due, or a C19 notice is issued as already told, and a recovery officer of ESIC recovers that amount from the employer. Once C19 is issued in 45A or 45AA cases, only appeal lies in the court of law, nowhere else. So this is how the notices of ESIC work. Now from the day the contribution is determined till the date of actual payment, ESIC claims interest from the employer for delayed payment and also claims damages. So what are those notices? How to identify them, what is the rate of damages. That part we will see in part 3 of this series. All the best to all of you. Subscribe to my channel for updates on ESIC. Thank you very much.